to enhance the regulatory regime for combating money laundering and terrorist financing, in fulfillment of Hong Kong's obligations, under the Financial Action Task Force, the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, Cap. 615, has been amended to introduce a registration regime for dealers in precious metals and stones, for commencement on April 1, 2023. Hong Kong Customs takes charge of the regime to enforce the registration requirements and supervise the anti-money laundering and counter-terrorist financing conduct of registrants. This video clip will illustrate the arrangements in detail. There are 4 types of regulated articles under the registration regime, which include precious metal, precious stone, precious product, and precious asset-backed instrument. Precious metal refers to gold, silver, platinum, iridium, osmium, palladium, rhodium or ruthenium, in a manufactured or unmanufactured state. Precious stone refers to diamond, sapphire, ruby, emerald, jade or pearl, whether natural or otherwise. Precious product refers to any jewelry and watch that is made up of, containing or having attached to it, any precious metal or precious stone, or both. Precious asset-backed instrument refers to any certificate or instrument backed by one or more precious metals, precious stones, or precious products that entitles the holder to such assets, in entirety or in part, but does not include any securities, a futures contract, any interest in a collective investment scheme, a structured product or an OTC derivative product as defined by the Securities and Futures Ordinance, Cap. 571, or a virtual asset. What is a business of dealing in precious metals and stones? Dealing in precious metals and stones business includes the following activities by way of business: trading in precious metals, precious stones, or precious products, including purchasing and selling, importing or exporting precious metals, precious stones, or precious products, manufacturing, refining or carrying out any value-adding work on precious metals, precious stones, or precious products, issuing, redeeming or trading in precious asset-backed instruments, or acting as an intermediary in respect of the above activities. Exception is provided for any person carries on a logistics service business, which only imports and exports precious metals, precious stones, or precious products in the ordinary course of that business. Any person who is seeking to carry on a business of dealing in precious metals and stones in Hong Kong, and engage in any transactions with total value at or above 120,000 Hong Kong dollars, or an equivalent amount in another currency, in Hong Kong, whether making or receiving a payment, is required to register with Hong Kong Customs. Please note that the transaction could be executed A. in a single operation, or B. in several operations that are linked or appear to be linked. Any dealer who intends to engage in non-cash transactions with total value at or above 120,000 Hong Kong dollars in the course of business, also known as specified transaction, such as using credit card, electronic payment, and check, is required to register as a Category A registrant. Any dealer who is seeking to engage in cash transactions with total value at or above 120,000 Hong Kong dollars, also known as specified cash transaction, and non-cash transactions with total value at or above 120,000 Hong Kong dollars, also known as specified transaction, in the course of business, is required to register as a Category B registrant and subject to anti-money laundering and counter-terrorist financing supervision. For dealers who carry out cash or non-cash transactions with total value below 120,000 Hong Kong dollars, no registration is required. Entities exempted from the registration requirements include banks, certain financial institutions that are already regulated under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, Cap. 615, and whose precious metals and stones business is ancillary to their principal business. Pawnbrokers which are already subject to the regulation of the Pawnbrokers Ordinance, Cap. 166, and non-Hong Kong precious metals and stones dealers. An applicant may choose to make an online application through the Dealers in Precious Metals and Stones Registration System, DRS, or submit a completed application form together, with the copies of the requisite documents by post or in person, to the Dealers in Precious Metals and Stones Supervision Bureau of Hong Kong Customs. Application for Category A registration. An application for Category A registration must contain a completed application form. Form 1A, BR, is for an applicant holding a valid business registration certificate. Form 1A, H, is for an applicant holding a valid license issued under Part 2 of the Hawker Regulation, Cap. 132, Subsidiary Legislation AI. In addition to application form, an application for Category A registration must also contain a copy of valid business registration certificate, or a copy of valid hawker license, addresses of all business premises and correspondence address, a declaration by the applicant that the applicant's precious metals and stones business has been carried on and will be carried on for a lawful purpose, and other supporting documents, such as a copy of Hong Kong identity card. Business premises include, but not limited to, any premises used for the purpose of a. the carrying out of face-to-face transactions with customers, b. the administration of the affairs or business of the applicant, c. the processing of transactions, or d. the storage of documents, data, or records. Applicants are also required to submit a copy of stamped tenancy agreement or record of ownership of the premises, or a copy of address proof which is issued not more than 3 months from now, such as utility or telecommunication bills, documents issued by banks, insurance companies, or government departments in Hong Kong. For residential premises or mixed commercial and residential premises, applicants are also required to submit copies of consent letters from every occupant of the premises to enable customs officers to enter the premises for routine inspection when exercising the powers under Section 9 of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. The person who submits the application form must be where the applicant belongs to sole proprietorship or hawker, the sole proprietor or the licensed hawker. Where the applicant belongs to partnership, the partner of the applicant authorized in writing by every partner, or where the applicant belongs to corporation, the director or senior staff member of the applicant authorized in writing by the board of directors. For Category A registration, the first-year registration fee is $260 and an annual fee of $195 is required thereafter. Upon receipt of all necessary documents, payment of the required fee, and vetting of relevant documents, Hong Kong Customs will notify the applicant of the application result. Obligations of Category A registrants. Upon granting of registration, a Category A registrant must display the certificate of registration in a conspicuous place at the principal place of business, and the branch certificate in a conspicuous place at each branch. If the registrant also carries on the precious metals and stones business on a website or any online platform, the registrant must display the registration information in a conspicuous place at the website or online platform. A register is also maintained by Hong Kong Customs. The register is available for public inspection at the registration office during normal office hours, or at the Dealers in Precious Metals and Stones Registration System, DRS, website. For any change of particulars of registration, such as change of name of registrant, addition or deletion of business premises, registrant must notify the Commissioner of Customs and Excise by submitting the completed Form 6 within 1 month of beginning on the day on which such change occurs. In order to obtain branch certificate for display at new branch or new temporary booth, the registrant shall notify the Commissioner of Customs and Excise of the opening of a new premises, which is intended to carry out face-to-face transactions with customers, by submitting the completed Form 5 at least 7 working days in advance. If a registrant intends to cease precious metals and stones business, the registrant shall, before the date of cessation, notify the Commissioner of Customs and Excise of the intended date of cessation, by submitting the completed Form 7. For details of the application for Category A registration, please refer to Part 1 and Part 2 of the Registration Guide. Application for Category B registration. An application for Category B registration must contain a completed application form. Form 1B, BR, is for an applicant holding a valid business registration certificate. Form 1B, H, is for an applicant holding a valid license issued under Part 2 of the Hawker Regulation, Cap. 132, Subsidiary Legislation AI. In addition to application form, an application for Category B registration must also contain a copy of valid business registration certificate, or a copy of valid hawker license, addresses of all business premises and correspondence address, while the definition and requirements of business premises are the same as Category A registration, and other supporting documents, such as a copy of Hong Kong identity card, a copy of address proof, and copies of consent letters from every occupant of residential premises or mixed commercial and residential premises. If the applicant is a local company, the applicant is also required to provide a copy of Certificate of Incorporation, a copy of the Form NR1 and all documents filed with the company's registry after filing of the latest NR1, a copy of Form NNC1 or Form NNC1G, information of group structure or percentage of shareholdings of each group member, a copy of Memorandum and Articles of Association, and Significant Controller Register. If the applicant is a non-Hong Kong company, the applicant is also required to provide a copy of Certificate of Registration of the non-Hong Kong company, a copy of Form NN3 and all documents filed with the company's registry after filing of the latest Form NN3, a copy of particulars of a non-Hong Kong company registered in Hong Kong, Form NN1, for new established company, information of group structure or percentage of shareholdings of each group member, and a copy of Memorandum and Articles of Association. Fit and Proper Person Test. According to the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, the Commissioner of Hong Kong Customs may grant a Category B registration to an applicant only if the Commissioner of Customs and Excise is satisfied that the individual, each partner, each director, each ultimate owner is a fit and proper person to carry on a precious metals and stones business, or to be associated with a precious metals and stones business. Who is required to apply for fit and proper person test? Where the applicant is an individual, the individual and each ultimate owner are required to apply for the fit and proper person test. Where the applicant is a partnership, each partner and each ultimate owner are required to apply for the fit and proper person test. Where the applicant is a corporation, each director and each ultimate owner are required to apply for the fit and proper person test. In the application for Category B registration, each entity required to be a fit and proper person has to complete his or her own fit and proper declaration form. Sole proprietor, partner, director, ultimate owner, licensed hawker is required to submit a Form 3A, together with Appendices 1 and 2, whereas corporate partner, corporate director is required to submit a Form 3B. When completing the Appendix 1 of Form 3A, the declarant must sign in the presence of a witness. The witness shall check the personal particulars as stated in the Appendix 1, against the original identity documents of the declarant, and certify that the personal particulars stated therein are true and correct. A witness refers to an authorized officer of Customs and Excise Department, a practicing professional, such as a solicitor, an accountant, or an auditor, a notary public, or a justice of the peace. If an individual wishes to request for an official of the Customs and Excise Department to conduct certification on his or her Appendix 1 of Form 3A as the witness, he or she shall attend the application interview in person with his or her original identity document. After verification by the official of the Customs and Excise Department, the individual must sign in the presence of the official, and the official would sign as the witness. An individual who makes a statement that is false or misleading in a material particular, or omits a material particular from a statement in Form 3A commits an offense. Who is an ultimate owner? According to the Ordinance, an ultimate owner is defined as follows. A. In relation to an individual carrying on a precious metals and stones business, an ultimate owner means another individual who ultimately owns or controls the precious metals and stones business, or, if the first mentioned individual is acting on behalf of another person, means that other person. B. In relation to a partnership, an ultimate owner means an individual who is entitled, directly or indirectly, to more than a 25% share of the capital or profits of the partnership. Controls, directly or indirectly, more than a 25% share of the capital or profits of the partnership. Is, directly or indirectly, entitled to exercise or control the exercise of more than 25% of the voting rights in the partnership, or exercises ultimate control over the management of the partnership. C. In relation to a corporation, an ultimate owner means an individual who owns or controls, directly or indirectly, including through a trust or bearer share holding, more than 25% of the issued share capital of the corporation, is, directly or indirectly, entitled to exercise or control the exercise of more than 25% of the voting rights at general meetings of the corporation, or exercises ultimate control over the management of the corporation. What are the criteria adopted by Hong Kong Customs for determining the fitness and propriety of a person? In determining whether a person is a fit and proper person, the Commissioner of Customs and Excise must have regard to the following matters. A. Whether the person has been convicted of an offense under ordinances including the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, the United Nations Anti-Terrorism Measures Ordinance, the Drug Trafficking, Recovery of Proceeds Ordinance and the Organized and Serious Crimes Ordinance. B. Whether the person has a conviction in a place outside Hong Kong for an offense relating to money laundering or terrorist financing which was necessary to find that the person had acted fraudulently, corruptly or dishonestly. C. Whether the person has failed to comply with a requirement imposed under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. D. If the person is an individual, whether he or she is an undischarged bankrupt or is the subject of any bankruptcy proceedings under the Bankruptcy Ordinance, Cap. 6. E. If the person is a corporation, where it is in liquidation or is the subject of a winding-up order, or there is a receiver appointed in relation to it. In addition to the above matters, the Commissioner of Customs and Excise may take into account any other matter that the Commissioner considers relevant. As such, Hong Kong Customs has issued the Guide on Criteria for Determining Fitness and Propriety, Category B Registration, to provide examples regarded as any other matter that the Commissioner of Customs and Excise considers relevant to help applicants understand the criteria for determining fitness and propriety. Examples include, but not limited to: 1. Whether the person has been convicted of a criminal offense which is not listed in Section 53 ZUN, in Part 5C, of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, but which has a significant and negative bearing on his or her honesty, integrity, and reliability. 2. Whether the person has failed to comply with any conditions imposed by the Commissioner on the registration. 3. Whether the person has any record of non-compliance with the Anti-Money Laundering and Counter-Terrorist Financing Ordinance or relevant regulation, which resulted in the taking of administrative action, prosecution, issue of written warning or has been disciplined by the Commissioner for the non-compliance. 4. Whether the person is in compliance with guidelines promulgated for Category B registrants in the regulatory regime, such as the Registration Guide and the Guideline on Anti-Money Laundering and Counterfinancing of Terrorism issued for Category B registrants dealing in precious metals and stones business. 5. Whether the person has the ability to carry on the precious metals and stones business competently, honestly and fairly and, in a manner which is not detrimental, or likely to be detrimental, to the interests of the customers or members of the public. Examples are the contravention of any law for consumer protection, or the Category B registrant has been the subject of any complaint made reasonably and in good faith relating to the Category B registrant's conduct of carrying on the precious metals and stones business. 6. Whether the person has been the subject of any proceedings of a criminal or disciplinary nature, or has been notified of any potential proceedings, or of any investigation which might lead to those proceedings under any law in any jurisdiction. 7. Whether the person has genuine intention and readiness to carry on the precious metals and stones business engaging in specified cash transactions as indicated in the registration application. For example, a Category B registrant has not carried out specified cash transactions for a prolonged period after the grant of registration without any good cause. 8. Whether the person has established effective anti-money laundering and counter-financing of terrorism systems to ensure compliance with all applicable requirements under the regulatory regime. An example is the person must appoint a compliance officer of a sufficient level of seniority and authority to oversee the establishment and maintenance of the company's anti-money laundering and counter-financing of terrorism systems. 9. Whether the person is equipped with the skills, knowledge, experience, and professionalism necessary to perform the precious metals and stones business's functions efficiently and effectively. In making such an assessment, the person is generally expected to be able to display an understanding of the statutory and regulatory requirements that are applicable to the precious metals and stones business. 10. Whether the person has been untruthful or provided false or misleading information, or omitted material information to the Commissioner of Customs and Excise, or been uncooperative with the Customs and Excise Department in the performance of a function under the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. 11. Whether the person is the subject of unresolved criminal charges in Hong Kong or elsewhere. 12. Whether the person has been censured, disciplined, or publicly criticized by any regulatory authority or professional body in Hong Kong or elsewhere. 13. Whether the person has been refused or restricted from the right to carry on any trade, business, or profession for which a specific license, registration, or other authorization is required by law in Hong Kong or elsewhere. 14. Whether the person has been disqualified by a court of competent jurisdiction from being a director. 15. Whether the person has financial integrity to ensure that the person has adequate financial resources for the nature and scale of its operations, and the financial position or solvency of the person would not undermine the interest of the customers and the members of the public. Examples are the person has failed to satisfy any judgment debt under a court order or made any compromise or arrangement with his creditors, and 16. The state of affairs of any other business which the person carries on, proposes to carry on, or has any business relationship. Examples are the other business which exposes the person to the potential risk of money laundering or affects adversely the person's financial integrity. Anti-money laundering and counter-terrorist financing measures. An applicant is also required to put in place an effective anti-money laundering and counter-terrorist financing system with a view to mitigating money laundering and terrorist financing risks. The applicant can choose to fill in and submit the pro forma on descriptions of precious metals and stones business and anti-money laundering and counter-terrorist financing measures, which contains the following information: company background and structure such as company history, organizational structure, number of employees, business nature, types of goods and services provided, etc. Profile of customers engaging in specified cash transactions such as ratio of walk-in to long-term customers, ratio of non-Hong Kong customers, major places of residence of the non-Hong Kong customers, expected yearly total revenue of the precious metals and stones business, total amount of cash to be received and delivered related to specified cash transactions, follow-up arrangements on cash received, etc. Anti-money laundering and counter-terrorist financing policies, procedures, and controls, including but not limited to putting in place adequate and appropriate policies, procedures, and controls, as evidenced by policy statements or other written documents. Conducting customer due diligence measures, including enhanced due diligence measures, to identify and verify the identity of the customers and their beneficial owners. Adopting the risk-based approach to continuously monitor its business relationship with the customers and their transactions. Putting in place a system or procedures to submit suspicious transaction reports to the Joint Financial Intelligence Unit, as required under the Organized and Serious Crimes Ordinance, Drug Trafficking, Recovery of Proceeds, Ordinance, and United Nations Anti-Terrorism Measures, Ordinance. Providing staff with appropriate training on prevention and detection of money laundering and terrorist financing activities, to raise their awareness of business practices against money laundering or terrorist financing. Providing staff with policies or guidelines in relation to the conduct of customer due diligence, criteria for identifying suspicious transactions, and relevant anti-money laundering and counter-terrorist financing measures for reference. Implementing an effective screening mechanism, and know whether the customers are politically exposed persons or from high-risk jurisdiction. Keeping records of transactions and records of customers obtained through customer due diligence measures. Applicants can also submit their own descriptions of precious metals and stones business and anti-money laundering and counter-terrorist financing measures. For details, please refer to the Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for Category B Registrants dealing in precious metals and stones. Applicants should have appropriate compliance management arrangements, which include the Senior Management Officer who is responsible for overseeing compliance management arrangements, approving and implementing effective anti-money laundering and counter-financing of terrorism systems that can adequately manage the money laundering or terrorist financing risks identified, and take enhanced measures to manage and mitigate the risks where higher risks are identified. A Compliance Officer who acts as the focal point for the oversight of all activities relating to the prevention and detection of money laundering or terrorist financing, and providing support and guidance to the senior management to ensure that money laundering or terrorist financing risks are adequately identified, understood, and managed. In particular, the Compliance Officer should ensure that staff training on anti-money laundering and counter-financing of terrorism is adequate, appropriate, and effective. A Money Laundering Reporting Officer, who acts as a central reference point for reporting suspicious transactions, and also as the main point of contact with the Joint Financial Intelligence Unit and law enforcement agencies. The Money Laundering Reporting Officer should play an active role in the identification and reporting of suspicious transactions, review of internal disclosures and exception reports, and provision of guidance on how to avoid tipping off. The person to submit the application form for Category B registration is the same as that for Category A registration. For Category B registration, the registration fee for the first 3 years is $1,970 plus $650 for each person, who is subject to the fit and proper test. The validity period of a Category B registration will be 3 years, and the registrant is required to apply for renewal of the registration at least 60 days before expiry. The renewal application fee is $1,060 plus $650 for each person, who is subject to the fit and proper test. Upon submission of all necessary documents and payment of the registration fee, the applicant will be required to attend an interview. During the interview, officials of Hong Kong Customs will verify the original documents and the payment record. The applicant will be required to clarify and elaborate any information of the submitted documents in relation to the application, and sign on the documents. To ensure that the applicant can fully understand and fulfill the obligations of a Category B registrant, the applicant will be briefed on the statutory registration and compliance requirements applicable to a dealer in precious metals and stones Category B registration by the officials of Hong Kong Customs. Upon the interview and relevant assessment, Hong Kong Customs will notify the applicant the application result. For details of the application for Category B registration, please refer to Part 1 and Part 3 of the Registration Guide. Obligations of Category B registrants. Upon granting of registration, a Category B registrant must display the certificate of registration in a conspicuous place at the principal place of business, and the branch certificates in a conspicuous place at each branch. If the registrant also carries on the precious metals and stones business on a website or any online platform, the registrant must display the registration information in a conspicuous place at the website or online platform. The register is also available for public inspection at the registration office during normal office hours or at the dealers in precious metals and stones registration system (DRS) website. Besides, when there is a person proposing to become the registrant's partner, director, or ultimate owner, the registrant needs to seek prior approval from the Commissioner of Customs and Excise by making an application via Form 4. Same as Category A registration, for any change of particulars of registration, such as change of name of registrant, addition or deletion of business premises, registrant must notify the Commissioner of Customs and Excise by submitting the completed Form 6 within 1 month of beginning on the day on which such change occurs. In order to obtain branch certificate for display at new branch or new temporary booth, the registrant shall notify the Commissioner of Customs and Excise of the opening of a new premises, which is intended to carry out face-to-face transactions with customers, by submitting the completed Form 5 at least 7 working days in advance. If a registrant intends to cease precious metals and stones business, the registrant shall, before the date of cessation, notify the Commissioner of Customs and Excise of the intended date of cessation, by submitting the completed Form 7. Furthermore, Category B registrant, when engaging in any cash transaction with total value at or above 120,000 Hong Kong dollars, is subject to the requirements set out in Schedule 2 of the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, which include, but not limited to, customer due diligence, which includes identifying the customer and verifying the customer's identity using documents, assessment of the risks, and taking appropriate measures to mitigate the risks. Where the money laundering and terrorist financing risks are high, the Category B registrant should conduct enhanced customer due diligence measures. Record keeping. Keeping records such as records of transactions, records of customers obtained through customer due diligence measures, screening results, and measures adopted for at least 5 years. Adopting a risk-based approach to end money laundering and counter-financing of terrorism, which allows a Category B registrant to allocate its resources more effectively, and apply preventive measures that are commensurate with the nature and level of risks. Independent audit function. This function should have a direct line of communication to the senior management of the Category B registrant, and have sufficient expertise and resources to enable it to carry out its responsibilities, including independent reviews of the registrant's end money laundering and counter-financing of terrorism systems. Ongoing monitoring. A Category B registrant should review documents, data, and information from time to time for the purpose of ongoing customer due diligence, and conduct transaction monitoring in relation to all business relationships following the risk-based approach. Employee screening procedures. A Category B registrant should have adequate screening procedures in order to ensure high standards when hiring employees. Staff training. A Category B registrant should provide adequate training for all new staff, frontline personnel, back-office staff, managerial staff, and money laundering reporting officer so that they are adequately trained to implement its end money laundering and counter-financing of terrorism systems. Regarding the above requirements, a registrant must read the Guideline on End Money Laundering and Counter-Financing of Terrorism for Category B registrants dealing in precious metals and stones, carefully to understand the relevant details. Besides, when a person, including Category A registrant and Category B registrant, knows or suspects that any property is proceeds of drug trafficking or an indictable offense or terrorist property, or was used in connection with drug trafficking, an indictable offense or terrorist act, or is intended to be used in drug trafficking, an indictable offense or terrorist act, he or she should report his or her knowledge or suspicion to the Joint Financial Intelligence Unit as soon as practicable. To enable any person who is seeking to carry on a business of dealing in precious metals and stones in Hong Kong to perform a quick and simple self-assessment on whether he or she is required to apply for registration, the appropriate category of registration, and his or her eligibility and readiness to apply for registration, Hong Kong Customs has launched an online self-assessment tool, the DPMSI Pass. By answering questions set out by the tool, a dealer can assess his or her eligibility and readiness to apply for registration. For more details of the registration regime for dealers in precious metals and stones, applicants can refer to a series of guidelines provided by the Hong Kong Customs, including the Registration Guide, Guideline on End Money Laundering and Counter-Financing of Terrorism, Disciplinary Action Guideline on Imposition of Pecuniary Penalty, Guide on Criteria for Determining Fitness and Propriety, and User Manual for Dealers in Precious Metals and Stones Registration System, DRS. If you have any other questions, please contact the Dealers in Precious Metals and Stones Supervision Bureau of Hong Kong Customs, or you can visit our office during office hours. Goodbye.